Two major decisions of the Presidential Election Petition Court I strongly disagree with, and why. Adegboruwa San says, welcome to the news and please subscribe to our channel. Eminent lawyer and right activist Ebun Olu Adegboruwa San has said that there are serious issues contained in the judgment of the Presidential Election Petition Court that will require further interpretation. Adegboruwa, in part 1 of an article entitled "The Crucial Verdict," made available to News Expression today, being Tuesday, cited two such judgments, the ones on testimony of witnesses and electronic transmission of results. He wrote on testimony of witnesses, "I noticed the court disqualified some witnesses on subpoena based on the fact that they failed to front-load a witness statement on oath before the court. In the first place, a subpoena is an order of a court commanding a witness to appear in court to give evidence or to tender a document. In some cases, these witnesses are government officials who ordinarily should not be within the reach of any parties. By issuing a subpoena, he is made to be a witness of the court. In some other cases, there may be hostile witnesses who have been summoned by force to testify. In any case at all, witnesses on subpoena should not be made to depose to any statement on oath. It was the court that summoned the witnesses in the first place and obeyed the order of the court to appear. In any event, subpoenas do not normally contain any directive for the witness to depose to any statement on oath. How then can the same court that commanded the witness to appear before it to testify turn around to disqualify the same witness who is deemed to be a witness of the court? It just doesn't add up." On electronic transmission of results, Adegboruwa wrote, and I quote, "One of the contentious issues before the court was that of electronic transmission of results by INEC. It was the contention of petitioners that had INEC followed its own guidelines for electronic transmission of results for election results real time, then there would have been no cases of manipulation or suppression of results. In this regard, the court held that INEC is not under any obligation to electronically transmit election results. The court relied upon the previous decision of the Federal High Court and the Court of Appeal, which it held were binding on the petitioners. First, this was the first election and the petition arising from it was between different parties and under totally different circumstances. The court should have x-rayed the conduct of INEC in relation to the 2023 presidential election simpliciter, being the subject matter of the petition before it. INEC was not conducting the election of the Rotary Club, but the 2023 presidential election in which over 80 million people were registered to vote and over 300 billion naira spent from the common purse. If INEC had, through its own guidelines, voluntarily made a contract with the people of Nigeria, the court should hold it bound by that undertaking and, or at least, extend cogent reasons why it could not be done. A lot went into the 2022 Electoral Act, the high point of which was electronic transmission of results, which was meant to remove or reduce human intervention in the electoral process. The decision of the court that INEC is not mandated to transmit election results electronically is, with due respect to their lordship, a huge setback to election administration and management in Nigeria, as we will now go back to the days of manipulation, falsification of results, and general violence, thuggery, and even rigging. It has been said that the most potent of rigging an election is the stage of collation and transmission of results. By endorsing INEC lapses, the court has unwittingly reversed all the gains of the new electoral law on e-voting. The court was too fixated on technicalities rather than dwelling on the substantive flaws and misconduct of the electoral umpire. We surely should not and cannot allow INEC to run away with all the mistakes and failures of a 2023 presidential election. If nothing else, we should use the opportunity presented by these petitions to identify the observable lapses associated with the presidential election with the aim of correcting them to avoid the ugly situation where they could be deployed to haunt us in future elections." The erudite Silk, however, agreed with the tribunal on the status of FCT Abuja and nomination of candidates. On the status of FCT Abuja, he wrote, and I quote, In the 2023 presidential election, the candidate who was declared as winner did not receive 25% of votes from the Federal Capital Territory. It was a contention of the petitioners that failure to secure the mandatory 25% of votes from the FCT automatically disqualifies any candidate from being declared as winner of the presidential election. On this issue, the court held that a candidate who has won up to 25% vote in each of at least 25 states in Nigeria does not need to win 25% of the votes in the FCT Abuja. Abuja is one of the states in Nigeria. Abuja is no different from the other states and does not enjoy any special status. I tend to agree with this decision. The FCT Abuja has only 6 area councils. The total votes cast for Senator Ireti Kingigbe to represent House of Representatives for Alimosho Local Government Council, one of the 20 councils areas in Lagos State, not to talk of Kano or Oyo State. What then would qualify the voters of FCT to be rated over and above other voters in Nigeria? Is it the mere fact of its geographical location or its administrative status as the Federal Capital Territory city of Nigeria? The Constitution itself states in its section 42 that no citizen of Nigeria shall suffer any discrimination, disqualification, or disenfranchisement to which other Nigerians are not subjected to by reason of his geographical location or circumstances of his birth. Is it an offense to be born in Port Harcourt or to live in Oka? Why should I suffer inferiority status because I voted in Ondo State compared to my fellow freeborn citizens who voted in the FCT? There is no reasonable logic behind this proposition at all. The FCT has no assembly, but rather it is the National Assembly that makes laws for it. It has no governor and no life of its own beyond the federal government of Nigeria. Taking it further by the principle of federalism, it is the FCT that should be rated lower in rank to the states. On nomination of candidate, Adegboronwa had this to say, and I quote, "To my mind, the issue of who represents a political party in any election should strictly be the internal affairs of the party in question. Although the Electoral Act now confers locus standi on any interested person to challenge the eligibility of any candidate, this should be guided by the principle that an outsider cannot cry more than the bereaved. More importantly, however, this issue was decided by the Supreme Court in May 2023, and some of the lawyers for these petitioners were said to have been involved in that case, and indeed other cases wherein the issue of the status of the candidate had been resolved. It amounts to professional misconduct for a counsel who is aware of a decision of the Supreme Court that has decided an issue against him and his client to seek to litigate the same issue. If at all this should be allowed, counsel owe a sacred duty to the court to make full and frank disclosure of the said case by stating the fact of that case and the decision reached on it. He can proceed to state the reasons why he's taking the different position in the present case or why he seeks a departure from the previous decision, but by all means, no one should abuse the court." Well, this is in fact, everything has been summed up here. He did a really good job. This is a beautiful piece. Only if the judiciary will say it that way. Alright, on this note, you've come to the end of the news. We say thank you for tuning in to listen. Until I come your way next time, enjoy.